Why has India rejected the supplemental award by Court of Arbitration, which is a part of dispute addressal mechanism in Indus Waters Treaty? What are the provisions of Indus Waters Treaty that we are seemingly violating as per Pakistan? And what lies in front of us when we have already suspended Indus Waters Treaty? India has rejected the supplemental award, the ruling that came in from the Court of Arbitration in context with the dams over the Indus water rivers. And this whole thing has been happening in context with the Indus Waters Treaty. But the question here is, what is the reason that India has rejected it, especially when the mechanism is stated in the Indus Waters Treaty itself? We will be looking into all these dimensions today. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh. Today we are going to understand that what is the reason for rejection of this ruling by Court of Arbitration, what are the dimensions related to Indus Waters Treaty which are contentious and have been contentious over timeline for Pakistan and India, and we will be also looking into the way ahead that is in front of India and Pakistan from here. Now starting with the Indus Waters Treaty itself, when we talk about this treaty, it was originated in 1960. Now, even though it came in almost 13 years later after the partition, but the issue had begun immediately after the partition, because how the distribution of Indus water system will take place, which is shared by the both countries, that is Pakistan and India. Now, this Indus Waters Treaty was brokered by the World Bank, and World Bank also became its guarantor. That means the implementation was guaranteed, would be facilitated by World Bank itself. Now in this treaty, there were particular provisions related to division, information sharing, etc. Now when we are talking about the division, the eastern rivers were given to India and the western rivers were given to Pakistan, and the division looked something like, when we talk about eastern rivers to India, it included Satluj, it included Ravi, and it included Byas. But when we talk about the western rivers which were given, it included Chenab, Jhelum and Indus. So when we are talking about this division, it was clearly demarcated that Ravi, Byas and Satluj is for Indian system, and when we are talking western rivers, that is basically Jhelum, Indus and Chenab, that goes to Pakistan. And when we are talking about the water usage of western rivers which do pass through Indian territory, India was also allowed some non-consumptive use on western rivers. By non-consumptive use, we mean that it should not be restricting the downstream flow. And if it's not restricting the downstream flow, that means it's not in violation of this treaty. So if it is being used for agriculture or hydroelectricity, navigation, that would be very much as per the provisions of the given treaty. Apart from this, there is also a provision related to data which has to be shared monthly by both of these countries in terms of the water that is being used. Now, whole of this treaty was put on abeyance. It was suspended by India after the Pahalgam terror attack of April 22, which took 26 lives, and it was carried out by a Pakistan-based terror outfit. Now, since the incident, the dispute we are talking about has its origins before that also, but this particular incident also marks a highlight, because if we talk about the provision of exit, there is no exit available as of now in the treaty, and for very long time India has been demanding that this treaty needs to be reviewed so as to maintain with the changing times. Now let us also look into the dispute resolving mechanism, because when this treaty was brokered, there will be disputes that would be arising. So there was a very simple dispute resolving mechanism was laid out, and it had various levels. So if the resolution was required at the questions level, there was establishment of permanent Indus Commission, which was any question based resolution required, which would be handled by permanent Indus Commission. The second level came in with a neutral expert. Now, if there was a situation where differences arose and a differences resolution was required, then the neutral expert would resolve that. and in terms of dispute, it was referred to the Court of Arbitration. Now, one thing we need to understand here itself, that India has always been in favor of using a neutral expert for resolution. They have never favored Court of Arbitration. It has mostly been Pakistan. In this particular dispute also, we will be talking about the dispute. It was Pakistan who initially wanted a neutral expert, then they switched their stand and they went for a Court of Arbitration resolution that they wanted. So this is the dispute resolution hierarchy which is given in the Indus Waters Treaty itself. Now, India has been very clear on this stance that they have facilitated neutral experts that have been appointed for the resolution as well. Now that we are clear with the provisions of the treaty which will help us to understand the dispute better, now let us move on to the dispute. Now, basically the dispute is regarding two hydroelectric projects, that is Kishenganga project that we have. Now, Kishenganga project is on the Jhelum river and the other project is the Ratle project that is on Chenab river. Now, both of these projects, you have to understand, they are run of the river projects and they are there for renewable energy generation. There are other projects as well which are under construction. For example, we have Pakaldul, we have Kwar, we have Kiru, and there are other dams like Uri 1, Uri 2 when we are talking about Jhelum itself. But we have to understand the dispute is regarding only two, that is Kishenganga and Ratle project. Now, both of these projects, because there was this issue dispute raised back in 2015 itself, when this dispute was raised, Pakistan as India wanted this resolution through a neutral expert. But 1 year later itself, in 2016, Pakistan went to the other tone as it usually does and it said we do not want to go for a neutral expert, we want Court of Arbitration, and India never agreed to that, because you have to remember this information to understand the rejection that India has placed as of now. So now when we are talking about this dispute, Pakistan is basically placing this allegation, this particular project violates the treaty provisions because it is affecting the downstream flows. And as per the provisions, downstream flows should not be affected of the western rivers because they are for Pakistan. And the design elements of these projects, how does Pakistan know the design elements? Because of the data sharing that happens between the two countries. For example, pondage capacity and spillway configuration, they are beyond the technical limits. So this treaty also places technical limits, right? So they are going beyond the technical limits. This is what Pakistan's allegation are. However, India has been very clear on that this project clearly complies with the Indus Water design norms that have been facilitated by the treaty. There is no diversion of water. They are run-of-the-river projects. That is why there is only regulated flow. And any technical objection, they will be heard by neutral expert. So they are saying that if you feel the technical limits given in the treaty are being breached, that can be checked by the dispute resolution mechanism set in by the treaty itself, and that we prefer neutral expert. We don't want Court of Arbitration here. So India is absolutely has answered all the allegations, and for the technical limit part, India is absolutely comfort. India had already mentioned that they want a neutral expert resolution. That's all. Now 2015, Pakistan, as I said, seeks neutral expert. 2016, Pakistan shifts its demand and India later protests the dual approach, because when this happens, World Bank parallelly starts both of these approaches. That means Court of Arbitration was also set, at the same time neutral expert was also appointed for the same dispute. Now India stands against this dual approach. India said, as per the Indus Waters Treaty, whatever is the decision regarding the dispute and its mechanism has to be taken by consensus. That is mentioned in the treaty itself, and because we are not okay with this Court of Arbitration, we have suggested neutral expert. It is Pakistan who is changing every time. So we are not comfortable with this, we do not want this, and we do not approve with this, and we do not sit with this. That is why Court of Arbitration is giving a supplemental award, or we can say the ruling that it has taken out does not make sense at all. We will get into the details of it once we have completed this part. Now we have understood what has happened, what is the dispute about, what did Pakistan say, what did India say, and what is exactly the timeline. Because as per the perspective, for the perspective of your exam, it is not about what Pakistan said, what India said. What becomes important, like the provisions of the treaty and how these treaties or rule-based order are important for bilateral relations, resolution of disputes, be it border disputes, be it water distribution disputes. Such rule-based orders are important, and if they are not implemented properly, then it would lead to chaos. Now let us move ahead and understand that why has India rejected this ruling. So I have set the base already for that I have explained that World Bank started parallel proceedings in 2022, and India totally went against this. India protested against this parallel proceeding of neutral expert and Court of Arbitration. Why World Bank's choice was both of them? Why? Because neutral expert was suggested by India and Court of Arbitration was Pakistan's request. And now in June, this Court of Arbitration, which is based in Hague, Netherlands, it has issued a supplemental award which is claiming jurisdiction over this dispute. Now this is totally unfair, and it is basically a charade, as if the Ministry of External Affairs has also given a statement at the behest of Pakistan. The reason being, this is something India never agreed to. So this does not make sense. It is absolutely null and void, whatever they want to say through this supplemental award or whatever jurisdiction they are trying to claim. It is not applicable to India. Furthermore, another pointer that comes in from here itself, that India has suspended this treaty. India is not part of this treaty. Just after the Pahalgam terror attack, IWT is in abeyance as of now from India's end. So any such decision is definitely not applicable. Furthermore, as the technical ground for this rejection is that the Article 9 of the Indus Waters Treaty clearly states that sequential and mutually agreed steps. So if we did not agree to this step states devoid of any legal standing, this court is illegally constituted, and this jurisdiction that Court of Arbitration has claimed, that has been clearly rejected. So India's rejection is very simple, that this is illegally constituted because we did not mutually agree to it, and we are not in abeyance with the treaty as of now. So whatever jurisdiction it is claiming, we are clearly rejecting this. India is in the times where India is already drawing clear red lines in terms of what it wants and what it doesn't, in terms of its global standing, and this is one such way of doing it and not falling in for the international pressure, especially in our internal matters that we see. Now the question that arises is that will Indus Waters Treaty remain suspended? So if we look at India's stand under international law as of now, so the treaty obligations can be suspended only when, if it's a sovereign decision, if the other party, here the other party is Pakistan, violates core principles. And India considers that terrorism support is a core principle that our neighbor has been violating for a while now, and this has repeated again in the Pahalgam terror attack, and that is why we are suspending this treaty. Any obligation by treaty does not stand, does not mean anything at all. Apart from that, India beforehand also has given formal notices. I am not talking about it in relevance with the Pahalgam terror attack. Even before that, in January 2023, September 2024, that means from past 2 years, there have been formal notices where India has asked for review and modification of the treaty, and India has said that there is requirement of adaptation to the changing geopolitical, climatic and security condition. And as of now, India continues to participate in the Indus Waters Treaty's resolution mechanism, where neutral expert mechanism is being used and refuses the arbitration court. So there is no final answer that if Indus Water Treaty will remain suspended, but the formal pleas by India have not been heard, and especially our neighbor has not been acting in the best way possible. So as of now, it does seem that this treaty is not going to continue from here on. But you tell me in the comment section that what will be the disadvantages that Pakistan will face in terms of discontinuance of this particular treaty, and what are the expected advantages that we can have from the discontinuance of IWT. Now that was all from my side. Thank you so much.